6:30.
All right, Mr. Seslick, are you able to hear me okay?
Yes, sir.
Mr. Trush, are you appearing on both the arraignments today?
I am, Your Honor.
All right, we'll go on the record in People versus Michael Seslick, case number 236612. The record should reflect Mr. Seslick's appearing today by video from the Otsego County Jail. Mr. Trush is here today for purposes of arraignment. Let's see. And Mr. DeLeo, you're here on behalf of the Probation and Parole Department in this case, is that correct?
Correct, Your Honor.
Okay, so I just want to make sure that I'm clear procedurally on what's gone on here. Mr. Seslick was placed on a delay of sentence in November. And then Mr. DeLeo, you asked to have sentencing on that matter based on a violation of the delay, is that correct?
Correct, Your Honor.
Okay, so then we set sentencing hearing for April 9th. Mr. Seslick failed to appear for that hearing. So the court executed bench warrant. And so that's why we're here today. Mr. Trush, have you had a chance to speak with Mr. Seslick?
I did, Your Honor. I would suggest to the court, I mean, I think the appropriate step to take at this point is to proceed to the sentencing on the underlying delay at this junction would be my request. Is there a prosecutor, though, in the courtroom?
No, we don't have anybody on behalf of the people here today for this hearing. So I agree with you. The court does need to reset this for a sentencing hearing. Anything else on behalf of Mr. Seslick?
I guess I would just I assume the court is likely going to set this for the beginning of June. I would just ask the court to address bond in the interim. Mr. Seslick is employed. He does also have some health concerns. So I would ask court to consider bond in the interim. Again, assuming the court's going to set at the beginning of July. I think a small period of release would allow him to get some affairs in order. Thank you.
All right, thank you. Mr. DeLeo, anything input on that from your side?
I would just point out, Your Honor, I mean, Mr. Seslick failed to appear for his original delay of sentence hearing. And then obviously failed to appear when we moved this up and asked the court to sentence him. I know he also had some absconder situations on his felony probation cases out of Genesee and Lapeer counties. So certainly there's some trepidation on the probation department that if he, does post bond and is released, that we'll be searching for him again and yet again delaying getting this taken care of.
All right, so the court notes Mr. Seslick previously failed to appear on March 6th of 2024, April 3rd of 2024. He failed to appear for a hearing on July 15th of 2024. And then it looks like he also failed to appear. Oh, then we scheduled the hearing for November. That's right. I do believe he was lodged during at least some of those failures to appear.
Yes.
However, that has been a pattern with Mr. Seslick. He is under sentence currently. He did enter a plea in this case. So the court finds that at this point, in order to ensure Mr. Seslick's appearance for the sentencing hearing, and to avoid further expense to the taxpayers and continuing to have to issue bench warrants and arrest Mr. Seslick, bring him back to court, The court is going to deny bond at this point. The court's going to order that his bond be revoked and he be held until the court can schedule that sentencing hearing. Mr. DeLeo, in terms of PSI, was one prepared already for that April hearing?
It was, Your Honor.
Okay, so is there anything that you need to, I'm assuming maybe an update, but is that something that would require, 30 days for you to prepare, or could we do that quicker?
I don't really even think an update needs to be done, Your Honor, other than potential jail credit, but if the court wants me to look into anything, I'm certainly happy to do that.
So, in Your Honor, the court can correct me if I'm mistaken on this. My recollection of my records reflect that ultimately the plea was to a 1-year misdemeanor. So I mean, I certainly don't object to having input from the probation department by way of a PSI. But again, I believe that the underlying plea was to a 1-year misdemeanor.
Yeah, yep. So what that means, I guess, for you, Mr. Seslick and Mr. Trush, is the court can, I'm going to try and get this on for a hearing prior to July. If I can get time at the court's June motion day, then we'll get it set for that time so that we can get Mr. Seslick sentenced and on his way, whether that's more jail time or released with credit at that point. So that's how we'll proceed. Mr. Trush, anything further today?
Not on this record, no.
Mr. DeLeo?
Nothing, Your Honor. Thank you.
Okay, that's all for this hearing today, and the court's going to disconnect on this file. All right, Mr. Lovely, are you able to hear me okay?
Yep. On the record in People versus Michael Earl Lovely, this is file number 225137 and 245341. The record should reflect Mr. Lovely's present today by video from the Crawford County Jail. Those file numbers are Crawford County file numbers, by the way. We're on the record here today for arraignment on one alleged technical probation violation and one alleged non-technical probation violation. Mr. Lovely, there's a few things I need to go through with you with regard to your rights. Number one, you do have the right to have a hearing as to whether or not you violated your probation as alleged. If you are found guilty of the non-technical probation violation, could subject you to a maximum penalty on your underlying charge. Which, Mr. McFalda, do you have the maximum penalty?
Judge, it's 5 years on his attempt possession of meth, and it's 2 years on the MDOP charge.
All right, thank you. Also, Mr. Lovely, you do have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Mr. Trush is here on your behalf today for purposes of arraignment. Mr. Trush, have you had an opportunity to speak with Mr. Lovely today?
I did, Your Honor. I do want to make one clarification. The paperwork that I got alleges 2 non-technical violations. The court said only 1. I just wanted to clarify that.
Nope, you're correct. I'm sorry. That is correct, Mr. Trush.
Okay. Okay, so with that in mind, then we'd waive a formal reading of the allegations. I went over them with him as well as what the maximum penalties are. He would plead not guilty to those charges today. He has been screened and qualified for counsel. Mr. Vernon will be appointed on that matter. And then at least at this time, I would request the court to set the hearing within the timelines. Mr. Vernon may well want to, at a later time, adjourn that out because there are new charges that form the basis for it. Mr. Vernon was appointed on those yesterday, but I don't want to compromise any timelines without him having an opportunity to look at anything.
All right, thank you. So the court will enter not guilty plea on behalf of Mr. Lovely with regard to all the alleged violations in both files. The court will set this for a hearing within that 14-day time frame as required by statute. Unless at some point prior to that, the defendant waives his right to that hearing. In terms of bond pending that hearing, Ms. Chady or Mr. McFelda, any input on that?
This is Dana Chady on behalf of the people, Your Honor. In this case, I just wanted to inform the court that in the new charge that Mr. Trush had just spoken about, Judge Burmeister had set a bond at $20,000 cash or surety. And I would ask this court to consider that Mr. Lovely has 3 probation violations and 2 different felony files in our court. Mr. Lovely has been given the opportunity of probation, and here we are again. Not 5 months after he was sentenced on the most recent file back for a probation violation. I think the court has given him lots of opportunity to exhaust that probation option. And I believe the court is aware of the significant criminal history of Mr. Lovely. There is about 10 to 12 misdemeanors. There is, I think this is the new case as of yesterday, which is the substance, is his 3rd or 4th felony charge. So it asks the court to consider all of those factors when establishing a bond between now and that hearing. Thank you.
Thank you. Mr. McFelda, anything you wanted to add to that?
No, Judge said, Ms. Cheney stated all the facts.
Thank you. Mr. Trush?
Your Honor, after discussing this with Mr. Lovely, I don't believe he can post the bond in the underlying matter at present, so we would not make an argument as to bond today and may address that to the court at a later date and time.
All right. Given all those factors as outlined by Ms. Chady, the court finds that in the interest, and I'm aware because the court also addressed the defendant's co-defendant in this issue on Monday, Ms. Bublitz. So the court's aware of some of the underlying facts regarding the allegations, which involve possession of methamphetamine, which also tested positive for fentanyl, and that Ms. Bublitz was in the car with Mr. Lovely along with a minor child. Given the dangerousness of those substances, particularly in the presence of a child, and Mr. Lovely's prior history, the court finds for purposes of public safety that a bond in the amount of $20,000 cash or surety is appropriate. So the court will set bond in that amount. Again, the court will set this for hearing, as I previously indicated. Mr. Trush, anything further on behalf of Mr. Lovely today?
Not today, Your Honor. Thank you.
Ms. Chady, anything further on behalf of the people?
Nothing further. Thank you, Your Honor.
Thank you. That's all for today, and the court